You're watching Bill on Bankruptcy. I'm Lee Pacquiao. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Welcome back, Bill. Thanks for joining us. So our case of the week is American Airlines. It looks like some astute junk investors are making boatloads of money on this case. Tell us how.
Boy, are they ever. You could have purchased the AMR stock in October for 40 cents a share. And guess what? As we speak right now, you would have made 10 times profit. In other words, the stock right now, last time I looked, is trading over $4 a share. This is for a company in bankruptcy.
Nice when it works, right?
This don't hardly happen. Well,
Yeah.
Here's what happened. Some folks figured out that because of the way the debt structure is for American Airlines, the holding company was solvent and people started buying stock. By October, before the merger with US Air was announced, the stock was up to about $1.20. I thought that was a pretty good price, but it didn't stop. By February, it had doubled into the range of $2.50 a share. And in March alone, the stock is up 50%. I don't know what the roof is for this stock. And by the way, the existing shareholders of AMR are not going to own either all or half of the merged airlines, US Air and AMR. They will own only 3.5% of the merged airlines. So that means people are putting a mighty high value on AMR and US Air when they get together in merger.
Now, not only are you telling us about the winners in the junk bond space this week, you have suggestions on how to avoid losses. What are they?
Yes, absolutely. And by the way, this was a bit of a surprise to me. You know, the ordinary intelligence in investing is diversification saves you from large losses. But evidently, when it comes to junk debt, that is what gives you losses. Our friends at Fitch Ratings did a study in which they determined that among 25 industries, the 5 worst industries at any particular point in time will give you about 70% of the defaults. In other words, the sick industries at any one time are going to produce most of the defaults. And so therefore, diversification is not the thing to do when it comes to buying junk debt. Rather, what you need to do is to look around and figure out what the sick industries are and avoid them like the plague. What they also told us in their rather interesting report was that over the last 30 years, the most defaults were in the industries of telecommunications, banking, autos, transportation, and textiles, while on the other hand, the fewest defaults were in real estate, energy, and pharmaceuticals. Now, by the way, keep in mind that what happened over the last 30 years does not mean the same thing will happen in the future, but at least if you avoid the bad industries, you can come out with your skin.
And we have a major settlement to talk about this week, Vitro. What happened there?
Well, Vitro blinked. Vitro is a very large Mexican glass maker, was principally in reorganization in Mexico. They proposed a plan where the Vitro subsidiaries that have all of the operating assets, in essence, voted to get rid of most of their debt. The U.S. bondholders, holding about 60% of $1.2 billion in bonds, thought this was practically laughable. And ultimately, the bankruptcy court said, no, Vitro, you cannot enforce your plan in the United States. It went to the Fifth Circuit Court of Appeals and was upheld. The plan being determined could not be enforced in the U.S. Here is the deal. The Vitro plan would have paid the investors in the bonds say 40 to 50%. This settlement calls for them to recover 85%. So shall we say they more than double their money, but that's not all, Lee. In addition, Vitro is paying them about $58 million for their counsel fees. So in other words, this, I guess, was a rather significant miscalculation by Vitro. What it tells us is if you sell bonds in the U.S. market, you cannot ignore the U.S. courts because they're going to have the final word on whether your plan works in a foreign country.
Let's hit the stats section. Bill, we've been talking about how bankruptcy professionals are all moaning about the lack of business. It's been pretty bad for quite some time. Is it going to get worse before it gets better?
You know, it may not. I'm not sure that 1 month is a trend, but here is the deal. It is very possible that bankruptcy filings bottomed out in January. Now, the filings in January were pretty low, but they rose in February. Not a huge amount, but they were higher. This is possibly the indication that we have hit rock bottom on bankruptcy filings. Frankly, it couldn't get too much worse for bankruptcy professionals, but I don't want to say that 1 month is a trend, but this could be, maybe we see the light at the end of the tunnel if it isn't the proverbial you-know-what.
We actually have a new filing to talk about now. Bill, we talked previously about how the bankruptcy judge in New York reluctantly sent the Patriot Coal case back to St. Louis, where the company was, I think, incorporated. Do you have further thoughts on the question of where bankruptcy should be filed, particularly as it pertains for this case that we're just going to talk about now?
Yes, there was a really interesting filing this week in Delaware by a small company called Entertainment Publications from Troy, Michigan. This company is not reorganizing, it is just liquidating in Chapter 7. It's got a whole mess of employees, maybe something like 250 employees. But as we said, they filed in Delaware, not at home in Michigan. This company may, and I stress the word may, have filed in Delaware because it's owned by a private equity investor named MHE Private Equity Fund. I really think the Delaware judges, on the long run, are going to be doing themselves a disservice if they allow these foreign Chapter 7 liquidations to stay in Delaware, because there is at least a possibility that they put this company in Delaware to be as far as possible away from the employees, who are frankly some of the interested parties in this case. One of these days, as we've said before, Congress may get into this issue of venue. It would really help a good deal, I think, to diffuse the issue if cases like this, that are not huge by themselves, are sent back to their hometowns. The Delaware trustees would like to keep these cases, by the way, because you don't get too many good asset Chapter 7 liquidations, and this would be one of them.
And finally, for our advance sheet segment, we go to the Ninth Circuit in California. What's happening in San Francisco?
Well, we may have a split of circuits on an issue that will go to the U.S. Supreme Court.
Oh boy.
If you're not somebody interested in Chapter 13 bankruptcy, well, listen, you can click off right now. But if you were a lawyer dealing with individual bankruptcies, pay close attention. This is very important. There is at present a split of circuits on the question of whether or not somebody with no disposable income in Chapter 13 must nonetheless have a plan that endures for 5 years. The panel of 3 judges in the Ninth Circuit in a case called Danielson versus Flores held in 2012 that the plan can be less than 5 years. This created a split of circuits with 2 other circuits. The entire Ninth Circuit is rehearing this case in the Danielson case, I think the 19th of March. If the Ninth Circuit agrees with the panel decision, then we have a stark split of circuits on what has been a very ticklish Chapter 13 case. And this, I think, is a pretty good shot for going to the U.S. Supreme Court.
All right, we'll have to see how it goes. Bill, thanks for that.
You're welcome.
That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. That's what we have for this week. I'm Lee Pacquiao. Thanks for watching, and see you next week.